All right. Thank you, everyone, so very much for making the time in what is likely finals week. So I appreciate you taking a break from that stack of grading that you're also very eager to get back to. This is the final law and court section brown bag for 2021. And this panel is on attorneys at home and abroad. We're very fortunate to have Amanda Hollis-Brusky as our discussant, and we have 3 fantastic papers for today. Amanda, how long did you want folks to go with their presentations?
I don't remember what we had agreed upon, but 10, 15, is that what, Tom, is that what you're saying, 15?
I think it was 15.
Okay.
15.
15's fine. Yeah, 15's fine.
All right, great. I will keep time. I guess I'll just drop into the chats to the to the presenter. 5-minute and 2-minute warning. Excuse me. After that, Amanda will have some comments, and then we'll open it up for just a general discussion at the end. I do not have the program in front of me. I think, Tom, you were listed first on the program. Yeah, good enough. We'll wing it a little bit. So our first presenter is Tom Pavone. And Tom, feel free to share, and it's all yours.
Okay, perfect. Can everyone see my my slide? All good? Awesome.
Yes, we can.
Well, thanks so much, Shane, for inviting me to this brown bag, and very much to Amanda for serving as discussant. I'm really thankful for the opportunity to share some findings from my forthcoming book, which is titled The Ghostwriters, Lawyers and the Politics Behind the Judicial Construction of Europe. So today I'm going to talk about law and policy making in the European Union. Now, the EU is a perplexing beast because on the one hand, it's an inexhaustible producer of law. Its corpus of rules span 350,000 pages that would stretch for 120 miles if placed side by side. But on the other hand, the EU lacks a transnational army and a capacious bureaucracy to enforce these laws. So how is governance possible in these conditions? And the conventional answer is that the EU relies on a transnational network of activist courts. Pioneered by scholars like Alex Stone-Sweet in the book here pictured, this view holds that audacious national judges mobilized to hold their states accountable to their legal obligations in order to bolster their own power. But how did they do it? Well, this view kind of has a particular narrative. Before the EU's existence, each European state had its own domain of national law displayed here in green, and lower courts and national judiciaries were bound to Supreme Court's interpretations of these laws if they didn't wish to see their decisions overturned upon appeal. But once a European community was created by the Treaty of Rome in 1957, a new field of international law was forged, along with a European Court of Justice, or ECJ, that quickly proclaimed that European law was supreme over conflicting national legislation and could be directly applied by even the humblest local judge. And these local judges were presumably all too eager to pounce on this opportunity. Whenever they encountered a law or Supreme Court decision that they disliked and that violated European law, they referred these cases in earnest to the ECJ via a mechanism in the Treaty of Rome known as the preliminary reference procedure. And through this alliance, the ECJ and national judges empower themselves to review the legality of national legislation and to overturn the decisions of national Supreme Courts. And in turn, national judges supplied the ECJ with the cases it needed to become the world's most effective supranational court. Now, this is the narrative of triumphant judicial entrepreneurship that captured my imagination as a PhD student. But when I began visiting national courts in Europe in the summer of 2015, I quickly butted heads with a very different reality. I encountered courts that were overworked and understaffed. I learned that most national judges had never received any training in European law. I realized that overworked judges are reluctant to apply international rules that they don't know. And I learned that judges in civil service judiciaries are reluctant to exercise the judicial review powers that we take for granted in the United States. So in order for these judges to become transnational policymakers and motors of Europeanization, they needed a vigorous outside push. And this is the core argument of my forthcoming book. National judges broadly resisted empowering themselves with European law because they were constrained by excessive workloads, lackluster legal training, and the careerist pressures of their judicial hierarchies. So the catalyst of change proved instead to be a group of what I call Euro lawyers who faced fewer bureaucratic shackles. Under the sheepskin of rights-conscious litigants and activist courts, these lawyers sought clients willing to break national laws conflicting with EU law. They then lobbied judges about the duty and benefits of upholding these rules, and they propelled them to solicit the European Court of Justice by ghostwriting their referrals. So beneath the radar, Europe has been built by lawyers who converted state judiciaries into transmission belts linking civil society with supranational institutions. Now, to walk through this argument rather breezily, I'll briefly mention the research design that undergirds it. I'll show you some evidence of Euro lawyers' political impact and how Euro lawyering has evolved over time. And I'll conclude with 3 broader takeaways on the politics of lawyers. So in brief, my analysis is based on 15 months of field work between 2015 and 2018 in the 3 largest founding member states of the EU, that's Italy, France, and Germany. Now, as researchers, we can't conduct fieldwork in countries as a whole. We must pick specific field sites. So to do this, I first mapped the distribution of all cases referred by national courts to the ECJ. And you can see these cases here where larger circles denote more referrals to the ECJ from judges in those locations. And I then chose to visit some cities where local courts had referred a lot of cases. We might call these hotspots in the judicialized enforcement of EU law. And I counterbalanced these with more intermediate or cold spot locations to find out what was missing in those places. Now, throughout, I gathered 3 sources of evidence, not only the geocoded litigation data that I just showed you, but also over 350 interviews with lawyers and judges, as well as previously unavailable archival documents from the historical archives of the EU and from the personal archives of lawyers. So what I found is that lawyers in Europe catalyzed the judicial construction of the EU by breaking from conventional lawyering. In this traditional view, lawyers serve as go-betweens or as resources to be mobilized, wherein you have a rights-conscious client who solicits a lawyer, who then represents the client's interest before an authoritative, capacious judge, who then issues a decision. Instead, I found that lawyers had served as ghostwriters of judicial policymaking. They actively sought out clients to challenge national laws violating EU law. These clients then performed an agreed upon solicitation. And then when faced with a bureaucratically constrained and undertrained judge, these lawyers would propose draft decisions which judges would then adopt. With the main difference between these 2 models is that whereas in the go-between model, agency sort of flows through the lawyer, in the ghostwriter model, agency radiates out of the lawyer who becomes the driver of court-driven change. Now, the pioneers of this form of ghostwriting in the 1960s and 70s were few and far between. In fact, my research led me to the trails of just 12 teams of lawyers. And here they are. And as you might expect, these lawyers were not representative of the bar as a whole. They had certain distinguishing traits in common. First of all of them survived the Second World War and were old enough to remember the war. Some had their property expropriated, lost family members, or had their own close calls with death, which means that they were very skeptical of state power and politically committed to uniting European states through law. Second, a majority of these lawyers acted upon this political idealism by founding the first transnational lawyers associations to promote the practice of European law. And finally, as I consulted their writings and interviewed the pioneers who were still alive, it was clear that they saw their lawyering as a politics via other means, and they relished their mischievous capacity to catalyze policy reforms through their litigation efforts. Now, what's really striking is that these lawyers solicited almost half of all national court referrals to the ECJ through 1980, almost 500 cases in total over the course of their career. Some 88 courts in 74 cities solicited the ECJ for the first time when one of these lawyers showed up. And what's more, nearly half of those courts would never refer a case again unless one of these lawyers showed up again. One of the ways that these Euro lawyers achieved this remarkable outcome was by ghostwriting the referrals to the ECJ that national judges lacked the time and the knowledge to draft themselves. And here I want to show you an archival example from the 1970s from a Euro lawyer in Paris named Lise Funk-Bretaneau. Funk-Bretaneau was a Jewish survivor of the Holocaust and a refugee during the Second World War. And upon the creation of this European community, she became the determined agent of Europeanization. In this particular case, challenging trade restrictions on exports to the UK, she was appearing before the Commercial Court of Paris. And this court was infamous. Not only had it never solicited the European Court, but in a prior lawsuit, its judges had even queried what the European community was about. And this is almost 20 years after it was established. So Ms. Funk-Bretaneau decided to hold the judges by the hand and engage in what other lawyers described as spoon feeding. She walked the judges through the A's, B's, and C's of the Treaty of Rome, including by quoting Article 177 and explaining how it empowers national judges to refer cases to the ECJ. And then she ghostwrote the exact questions that the judges could pose to the European Court, which were framed as to push the ECJ to strike down the national legislation at hand. And the judge proceeded to copy this text verbatim without changing a word. And this is the type of evidence that I repeatedly encountered in the archives. Now, with time, this form of Euro lawyering underwent a temporal process of corporatization. The pioneers of Euro lawyering may have been motivated by idealism, but they invented a repertoire of strategic litigation that could be co-opted by a rising network of corporate law firms. Now, through the 1980s, big law was largely absent in Europe, hampered by national restrictions on inter-firm mergers and the number of firm offices. But as global competitive pressures and lobbying from the American and British law firms chipped away at these restrictions, the rise of European big law began to take off. And here's a graph of the growth across Italy, France, and Germany of branch offices of corporate law firms specializing in EU economic law, as ranked in two influential law reviews, Chambers Europe and the Legal 500. By paying high salaries and linking lawyers to deep-pocketed clients willing to fund ambitious escapades to the ECJ, these corporate firms plucked aspiring EU lawyers from markets of lesser centrality and forged a corporate ecology of Euro lawyering. And here is what it looks like on a map. In blue is the distribution of Euro firm branch offices across Italy, France, and Germany since the 1960s. And if we then superimpose some heat maps showing where national judges refer more cases to the ECJ, over time you can see that there's a growing congruence with where these big law firms are locating and where judges solicit the court more. But here's the thing, these Euro firms are not just locating randomly. Overwhelmingly, the hotspots of these firms are wealthier global cities where lawyers can tap into hubs of financial services and multinational corporations. And if we compare these to the cold spot locations where judges seldom refer cases to the ECJ, not only are these cities much more marginalized in the European market, but not a single Euro firm has opened an office in these sites. Now, this uneven corporate ecology has had a profound impact on the legal consciousness of lawyers and judges on the ground. In wealthy global cities, mobilizing European law has become a daily affair. But in most other locations, EU law gets perceived as distant, impractical, even neglectful. Take the view of a young lawyer in one of the cold spots who got his master's in EU law and then interned at the European Commission in Brussels. When he then returned to his hometown of Palermo to become a Euro lawyer, he realized he could not. He told me, quote, "When you came back here, you felt strangely alone. You were a sort of extraterrestrial. My sister gifted me some business cards that read, lawyers specializing in European law. And if I handed out those cards, I would have never been able to work again because people would say, all right, he does international law. What the heck is he doing here?" Now compare this experience to a corporate Euro lawyer in Paris who concluded our interview intent on emphasizing the incestuous micro world in which he became embedded. He told me, quote, "EU litigation takes years, it's very expensive. So who can pay for this? It's the big businesses. So most lawyers will say, I'm going to go to a law firm that will value my experience and my training. I'm going to Paris or London. And I haven't seen this so much elsewhere, this incestuous aspect. Because in truth, the judges, the lawyers, and those who are judged, that is the in-house counsel of the big businesses, they frequently meet up with each other. After the hearings, they go to dinner together. Sociologically, it's a micro world, end quote. So in short, instead of the political idealism of the first Euro lawyers fueling the judicial construction of Europe, increasingly it's the economic self-interest of corporate law firms that determines where EU law is mobilized and judicially enforced. So let me conclude with 3 brief takeaways regarding the politics of lawyers more generally. And in fact, the first takeaway is that this is hardly a European story. The protagonists of my talk tapped opportunities for transnational policymaking that are on the rise outside of Europe as well. Over the past 2 decades, there has been a profusion of international courts with compulsory and permanent jurisdiction. But what's really significant is that there are now a dozen transnational courts emulating the EU's referral procedure. So these are courts that empower local civil society to challenge their state through a transmission belt linking national courts with international judges. Now, not all of these courts are active or authoritative, but the opportunities to engage in the type of political lawyering that I've described have certainly proliferated since the end of the Cold War. Second, lawyers are not just pawns maneuvered by others. Treating lawyers as resources or merely stressing which of their attributes leads to wins or losses in court misses how lawyers can serve as autonomous agents of change. Lawyers have their own interests and identities, their own strategic repertoire, and it's their unique mediatory position between civil society, states, and international organizations that opens a space for them to shape political development. And finally, if we study judicial policymaking solely by focusing on the behavior of judges, we risk neglecting a crucial arena of political action. All courts face resource scarcities and knowledge deficits, and this means that judges' behavior can very much hinge on how they're mobilized by lawyers. It's thus misleading to attribute the growing policymaking role that many courts play around the world to a kind of innate judicial activism. We would be better served by flipping this presumption on its head and paying closer attention to the actors who make ghostwrite what courts do. And with that, I'll just say thank you for your attention, and I very much look forward to your comments and your questions.
All right, thank you very much, Tom. Next up, we have David Trowbridge. David, all yours.
Awesome. All right, just make sure that works. Do you all see the PowerPoint slide?
Yes, we do.
Excellent. Pull up some notes here. Okie dokie. Title by paper is Serving Their Cause, Case Selection Processes and Cause-Lawyering Organizations. This is a study of legal impact organizations. So I'm interested in the behavior of cause-lawyering organizations, but we can really separate between direct legal services and these larger impact organizations. The question of my paper is, how do these cause-lawyering organizations, how do they go about selecting what issues they're going to litigate, they're going to handle? To me, this is an important question for a number of different reasons. One, because cause-lawyering organizations are important parts of social movements, right? For better or for worse, they're part of setting the agenda for social movements. For better or for worse, they're part of framing the discourse on rights, and they are important drivers of legal, if not social change. They also are organizations with a finite amount of resources, right? They're not high-powered private law firms. They have finite number of monetary resources, staff, expertise. And so because of that, they have to make some difficult choices, right? And then there's also the literature on social movement organizations and from cause-lawyering literature that demonstrates that these organizations do not always work on or prioritize issues that are really important to the most disadvantaged subgroups of their target constituency. So for those reasons, I'm really interested in the inner workings of cause lawyering organizations. It also helps to know too, this is sort of a Frankenstein of a couple chapters from my dissertation, and I've been able to successfully peel away other parts of the project, but this part of the project has still left me with a number of questions, which I'm going to bring up now. It's sort of an odd thing to begin with, where I see all the problems in my project, but given the spirit of this being a brown bag and this being sort of an early stage project, I wanted to kind of express to you where I'm having a lot of misgivings here, and see if we can kind of suss out some answers to these. One is in the theory in the contribution. I'm not completely confident there is sort of a there. Is this really telling us something new, or is it telling us mostly things we already know? If so, is there a way to gain greater leverage, maybe add another case study? And if that's the case, how would people suggest I approach case selection by, like, on what variables would I select a different case? And does this seem more just sort of like and I've seen people talk about these problems before, does this seem more of like a descriptive study that is maybe not appropriate for a political science journal, maybe more appropriate for a different venue, which is totally fine. No hard feelings. Critique is good. So I started with trying to come up with a general sort of theory, a scheme, a classification, if you will, of what to expect, as I go into, into this project. And based on the vast amount of literature, I sort of came up with this scheme here, which can definitely be improved upon. One is I sort of expected, based on the literature, to see a limited and to moderate influence of case diversity and community input. A moderate influence of funders, by which I mean major foundations and major donors. Moderate influence of the perception of the opportunities to win in court. Moderate to significant influence of individual staffers, by which I mean staff autonomy. And a limited influence from boards of directors. And really briefly on the methodology here, the larger project focused on more organizations. This paper really focuses on 4 current legal organizations in the LGBTQ movement: Lambda Legal, National Center for Lesbian Rights, GLAAD, and also the former Equality Advocates Pennsylvania. It's now a different policy-oriented organization, but it used to be a legal advocacy organization. The larger project had, a couple dozen interviews. This one really focuses on about a dozen. The larger project had 400 documents that I was looking through. This one really only focuses on a couple dozen of those. But by documents, so these interviews also are hour to hour and a half long, recorded mostly over the phone, somewhere in person. The documents include internal memos and emails, pamphlets, annual reports, things I collected from archives at Yale, San Francisco, and in New York City, and also publicly available annual reports and newsletters. And I'm going to go briefly over some parts of my analysis. As our discussant may have noticed, this is a 16,000 word behemoth. So going over all of it doesn't make much sense. So I'm going to do some of the highlights here about what I've found. I was personally surprised by the discussion, and also in sort of the internal memos, by the amount of staff autonomy that individual lawyers had in case selection. The literature kind of points this direction, but it still surprised me. I was told on a number of occasions that when if a staff member really pushes for taking a case, generally they're going to be able to do it. And when there is a sharp disagreement, it's going to be the legal director, not a board, that comes in and says no. And rather conveniently, when going through it was the Yale archives, I was going through a bunch of boxes that GLAAD had donated. There was, in the mid-1990s, sort of self-analysis that GLAAD did on how they select cases, like super conveniently, right? Like here is how we select cases, and here is how they compare to other organizations that select cases, and here is our process. So I was like, great, thanks for making it easy for me. And it's just a quote from this pamphlet. It says, or memo rather, it says, staff attorneys generally decide what cases to take by evaluating whether cases are clearly written within their mission, which we'll get to in a moment. If they have a question, they raise it with the legal committee, a committee chosen by staff attorneys that also has a board liaison who participates. This was in the mid-1990s. What I found is by early 2000s, mid-2000s, the distance between the director and individual staff autonomy had widened, right? In part as these organizations grow, staff autonomy generally increases. One of the things that really surprised me that wasn't in the literature, and I thought that maybe it was just sort of like window dressing at first when it was brought up, but seemed to have sincere influence on case selection, was the mission statement. This was brought up time and time again, that the staff would tie themselves, with this caveat that I'll get to the mission statement when they felt there was a tough decision in selecting on cases. And this is from Jansen Wu, who is still the current executive director of GLAAD. He says, and at first it kind of sounds like, just something a director would say, but then he goes into concrete details, right? So it says, at the end of the day, we are guided by our mission, and as long as we're using the resources to further our mission, that's what our compass point is. That's our North Star. I've learned a lot of the importance of being rigid about that from my predecessor. That's Lee Swislow. Whenever there was a hard decision to make, when there were competing interests, including interests from externally and funding sources, and we'll get to funding, then all eyes in the room were turned to Lee. Lee would always say, well, the question I always ask myself in these moments is what would further our mission? And Jansen says, this is how I approach these things. And he gave me sort of concrete examples of when they would take a case, and now I'll get to this actually later, and believe that they're probably going to lose and still do it because it furthered the mission in some way. And I also provide an anecdote in the paper that I think is really important, also from GLAAD, in which in the mid-1990s, GLAAD was having an internal debate about whether to include transgender rights in their mission statements, And the board originally, a couple times, rejected requests from, mailman is here, the requests from staffers to include transgender rights in their mission statements. And you can see in this exchange how important the staff felt this was to include this issue. And then what was really interesting and showed me the limit of the mission statement is that I found it along the same box, is that at the same time in the mid-1990s, GLAAD was also doing a fundraising for a new lawyer, and they got the money they needed. They hired a new lawyer, and who did the staff hire? Jennifer Levi, who is one of the most well-known preeminent transgender rights advocates in the country, right? So they found a way to work around the refusal of adding transgender rights into their mission statement. So it's not everything, right? But again, it kind of shows that relationship between staff autonomy, mission statements, and how to select cases. Then we get to major funders and donors. I analyzed decades worth of IRS 990 forms, annual reports, audited financial statements, trying to figure out what was potentially influential, or if I could find anything. And what I found surprised me a bit, and that was, in large part, the majority of funding was unrestricted, right? I expected to see much more restricted because the critical legal scholarship suggests that funders play a large role in constraining how these organizations work. Majority of the funding was unrestricted. The funding sources were very diverse, suggesting that not one major funder or donor can really control the budget. And that of the restricted donations, they're more likely to be time-bound than issue-bound. And then I'm not going to read all of these quotes, but interviewees also sort of backed up this, or this is really confirmed what interviewees rather were saying, and that is executive directors really try to isolate rank and file staff who are selecting cases from issues of donation. So the executive directors really take this on, and they found it as their job is to encourage donors to donate in an unrestricted way. And I was told would sometimes even reject donations if they felt that it didn't meet the mission statement. Now, not every organization is in a position to do this. And there were some other stories I was told about where it can be influential, but on the whole, a lot less influential than would have expected. And this was corroborated in part by these financial statements. And I think I'm going to finish on this one, because just for the sake of time, is that perception of opportunities to win. Again, I was sort of surprised by the fact that, yes, lawyers, they do want to win in court, but they will take a case as exemplified here in this quote, even if they think they're going to lose, because they think there is some other benefit, whether it's educational or otherwise, in selecting a case. So to quickly sort of wrap up here, I sort of compared my expected influence versus observed influences, and basically most things match up. There was a couple of surprises here. The mission statements were more important. I thought the educational value, which I didn't talk about today, but is in the paper, was more important than I would have expected. Collaboration, which I should have known from the literature was going to be important, but I didn't think of at the time, was influential. But for the most part, observations were basically what I would have expected here. But I think I'm probably out of time, so I'm gonna stop there, and thank you very much. Stop share.
All right, thank you very much, David. Our final paper today is by Dorian Kantor. Dorian, the floor is yours.
All right, so I've never actually used Zoom to do a presentation, so I apologize if this is starting off a little. Let's give me 1 second. All right, so you guys can see the PowerPoint? Excellent. All right, so today I'm going to talk about a project that I've been working on. This is actually my doctoral dissertation that I'm trying to turn into a book. And so the title of today's presentation is Lawyering Executive Unilateralism, the Office of Legal Counsel's Auto-Interpretation of the President's Power to Protect the National Security. Okay, so because of the tight schedule today, I'm going to present my research in broad terms, focusing on the underlying problematics and giving you a short case study in the end. So what is the puzzle that animates my research? The puzzle very briefly is that after September 11th, 2001, the Bush administration took sweeping unilateral actions to counter the terrorist threat and to bolster presidential power along the way, largely motivated by their ideological commitment to programmatic aggrandizement of executive branch authority, specifically in the realm of national security. As I argue in my research, this behavior was in stark contrast with the textbook presidency as law executor and with Richard Newstadt's bargainer-in-chief model. A particularly interesting aspect of the administration's unilateralism was its use of a novel legal strategy to enhance executive power and to devise a response to the terrorist attacks, while also relegating Congress and the courts to the sidelines. The notion that the executive has a mandate to interpret the laws is actually neither new nor all too controversial. In fact, several scholars have argued on normative grounds for presidential review, popular constitutionalism, or extrajudicial constitutional interpretation. As for the constitutional foundations of such interpretive behavior, we can look to the presidential oath clause or the take care clause, and to the absolute negative, the presidential veto. So in the original constitutional design, the president in the discharge of the executive function has at least a narrow space in which to act as much as an interpreter as an agent of the Constitution. Executive legal interpretation becomes more controversial if we consider the phenomenon of juridification, a transformative process within the state, both structural and cultural. Juridification denotes a set of processes that comprise both legal regulation of new areas with conflicts and problems increasingly being framed as legal claims, and the penetration of judicial ways of thinking and acting into new fields. Juridification of politics occurs with the transfer of decision-making authority and competence to legal institutions and the displacement of political conflict into the legal arena. In my research, I argue that the juridification of politics has created a conducive environment for the executive to absorb interpretive capacity and to rely on endogenously rendered interpretations of the Constitution and statutory law for unilateral executive action, and thus avoid the transaction costs associated with interbranch politics. In other words, politics as law. This interpretive capacity is exercised primarily by the Office of Legal Counsel, or OLC for short. This obscure but influential office of the Department of Justice acts as a mini Supreme Court that has final say in what the president and his agencies can and cannot legally do. Indeed, the Office of Legal Counsel's opinions figure prominently in this particular type of unilateralism that we see under, not only under Bush 43, but also under the under Obama in the Hollis-Brusky targeting memo, and of course also under Trump in the indictment memo, which of course falls outside of the purview of national security, but still it's very interesting. Here it's important to mention that many of the legal policy issues that OLC considers either never come before a court, or courts find themselves powerless to intervene for at least three reasons. First, in the American legal system, the federal courts do not issue advisory opinions under the limitations of the Constitution's case and controversy clause. Abstract legal questions or legal questions regarding contemplated action fall outside of the jurisdiction of the federal courts. Second, federal judges are generalists and suffer from epistemic limitations when it comes to national security. So they lack institutional competence, confidence, and resources to adjudicate such cases. Third, courts have certain self-imposed limitations based on doctrines of deference to the political branches. In Ochin versus Central Leather, the Supreme Court pointed out that, quote, the conduct of the federal or the foreign relations of our government is committed by the Constitution to the executive and legislative, the political departments of the government, and the propriety of what may be done in the exercise of this political power is not subject to judicial inquiry or decision. In my research, I have parsed and analyzed all of the national security related OLC opinions of the Bush administration, and I'm also working on the Carter OLC's opinions regarding the Iran hostage crisis, as well as more recent opinions from the Obama administration. I argue that OLC's legal opinions can be viewed as unilateral power tools. Indeed, what I call juridified executive unilateralism results in sweeping policy changes in multiple areas, obviating recourse to interbranch institutional cooperation. Here, I have the typology of OLC's power tools, sort of the results of my research, my findings. Number one is framework construction. Of course, if you look at the war on terror, the most basic element of the war on terror legal infrastructure, this war paradigm, the legal framework that OLC built for the Bush administration to be able to unilateralize policymaking in the global war on terror, allowing the commander-in-chief to retain near complete control of the war effort, and also, for example, blending notions of internal policing and external military activity, among others. Number two is usurping Congress's lawmaking authority or quasi-judicial legislation. In several of its opinions, OLC broadly construed the AUMF and continues to do so up to this day in order to claim statutory support for a vast range of unilateral executive actions, such as the use of military force, the use of drones, warrantless foreign intelligence gathering, the suspension of the Posse Comitatus acting, and others. Number three is nullifying domestic legislation, the rough equivalent of a line item veto, which is, of course, unconstitutional, but not if the OLC does it. Many of OLC's opinions also cause negative change. In other words, they undo existing statutory regulations. In the case of the Obama OLC, the famous targeting memo essentially nullified the constraints of 18 U.S.C. Section 1119, the foreign murder of a U.S. citizen, based on the virtually boundless public authority justification and argument that the Bush OLC, by the way, also used to rationalize torture by military personnel. Number 4 is nullifying international law. In its interrogation-related memorandum, the Bush OLC deployed the president's power to interpret treaties in order to narrowly construe UNCAT, the UN Convention Against Torture's definition of torture, effectively rendering its constraints inoperative. Number 5 is enhancing independent constitutional powers, and perhaps the best known feature of its interpretive activity, the Bush OLC's constitutional analysis generously interpreted the president's Article 2 powers, although as I will show in the case study, the commander-in-chief override was rendered unnecessary by the Supreme Court's decision in Hamdi. It doesn't mean that the argument went away, it just wasn't necessary to make the argument anymore. Number 6 is exploiting the structural position or institutional characteristics of the executive. For example, the Bush OLC defined the president's inherent power to use military force as flowing from the structure of the Constitution. Elsewhere, OLC argued that the institutional characteristics of the executive, such as unitariness, speed, secrecy, made it better suited for wartime decision-making than Congress or the courts. Again, think of the United States drone policy here. Number 7, very briefly, is changing the parameters of legal constructs. In one of its early legal opinions, the Bush OLC effectively changed the dimensions of the legal concept of exigency. These conceptual stretching resulted in the recalibration of the Supreme Court's applicable precedents and the creation of a freewheeling commander-in-chief authority to protect the United States from foreign threats such as transnational terrorism. The Bush OLC also imported a fixture of classical battlefield warfare into the non-traditional war against terrorism, the military commission. As a result of OLC's transplantation of military commissions into the war on terror, jurisdiction over the trial and punishment of enemy combatants was transferred from Article 3 to Article 2 courts, where it has remained ever since. Number 8 is status quo maintenance. It does not change the legal landscape. Instead, opinions that engage in this type of interpretive behavior insist on ceding no constitutional ground to Congress over a domain that OLC considers properly to belong to the president. One example is the War Powers Resolution. Number 9 is defining institutional power relations. Although not a unilateral power tool in the strict sense of the term, some of the Bush OLC's institutional powers arguments effectively redefined institutional power relations in the long term. And indeed, when the coordinate branches allow the president to take some form of unilateral action, it establishes a measure of institutional precedent, and repeated exercise of such activity in turn progressively entrenches it, along with OLC's legal analysis, into what eventually becomes quasi-constitutional custom. And number 10 is policy recommendation. Undoubtedly, OLC's function is strictly interpretive. Nevertheless, on numerous occasions, at least in the Bush corpus of opinions, OLC also expressed policy preferences on proposed specific actions. So it is by far the most blunt of the policy tools considered here, since policy recommendations essentially predetermine the best course of action to be followed. To wrap up this portion, legal interpretation to achieve politically desirable real-world outcomes implies not only the juridification of the juridification of the political, but equally importantly, the instrumentalization of the law. But this is a dangerous undertaking, since while political action based on such legal determinations carries an air of legitimacy, juridified executive unilateralism, as I call it, if unchallenged by the coordinate branches, inevitably alters the separation of powers and checks and balances, removes certain political decisions from the political arena, attenuates the connection between constituents and political actors, and narrows the space for collective action. Ultimately, taken to an extreme, rule by law supplants the rule of law. In the brief case study in the last few minutes of my presentation, I want to illustrate OLC's interpretive activity not through a single opinion, but through the evolution of its legal interpretation as a result of inter-branch interaction. A prominent feature of OLC's interpretive activity is what I call defensive risk management, or finding alternative legal avenues. After all, as Walter Dellinger wrote in 1996, OLC's duty is to pass the executive authority to its successor unimpaired by the adoption of dangerous precedent. Apart from defensive risk management, this case study also illustrates the enhancement of independent executive power, usurping Congress's lawmaking authority, nullifying domestic legislation, and defining institutional power relations. In the 20 Bush-era legal opinions that I dissect in my forthcoming book, Politics as Law, the AUMF is one of the most often cited legal authorities. Nevertheless, despite its broad and essentially unqualified grant of wartime authority, in the early years, the Bush administration relegated the AUMF to secondary status as supporting legislation, relying instead on the president's pre-existing constitutional powers. In most of the pre-2004 legal opinions, the AUMF functioned as a defensive risk management tool. In other words, a shield from potential litigation against executive unilateralism. OLC's logic was quite straightforward, where some executive actions found by a reviewing court to be in discord with any of Congress's co-equal powers, the president would essentially have a free pass in the form of authorizing legislation. The tendency to rely on the AUMF for legal authority in counterterrorism operations accelerated sharply after the Supreme Court's opinion in Hamdi versus Rumsfeld. The Bush OLC's legal opinions utilized the AUMF a total of 29 times between 2001 and 2003, but in the first opinion alone issued after Hamdi, OLC referenced the AUMF 31 times. So the court's overall favorable ruling in that case explains why. The court's plurality declined to entertain the government's original position that the executive's plenary authority to detain pursuant to Article 2 was sufficient to overcome the statutory prohibition against the detention of US citizens. But it did so because it found that the ruling on constitutional grounds was not necessary. Writing for the plurality, Justice O'Connor stated that the court need not reach the constitutional question because the government's alternative position that Congress had in fact authorized Hamdi's detention through the AUMF adequately resolved the matter at hand. O'Connor also concluded that the detention of enemy combatants in the global war on terror is so fundamental and accepted an incident of war as to be able to exercise as to be an exercise of the necessary and appropriate force Congress has authorized the president to use. Therefore, in litigation before the Supreme Court, the AUMF fulfilled its function as a defensive risk management tool, a shield to protect the executive's broad latitude to act independently from statutory limits in the AUMF authorized war on terror. For the Bush OLC, the operative language of the Supreme Court was Justice O'Connor's finding that the detention of enemy belligerents is a fundamental and accepted incident of war. Based on that wording, OLC declared that Congress in the AUMF gave its express approval to the military conflict against Al-Qaeda and its allies, thereby to the president's use of all traditional and accepted incidents of force in this current military conflict. Instead, it was front and center as the link connecting the Supreme Court's endorsement of the president's war powers and the executive's plenary authority over the conduct of hostilities. At the same time, it also functioned as a legitimating device with vastly increased potency, since it demonstrated not only Congress's support for the president's authority to protect the nation, but also adherence to Justice O'Connor's admonition that a state of war is not a blank check for the president. Based on this recalibrated argument, OLC concluded in its first post-Hamdi legal opinion that the AUMF had confirmed and supplemented the commander-in-chief's power to unilaterally authorize the NSA's intelligence gathering activities as a fundamental incident of the use of military force. So OLC moved the goalposts of the legal rationale. To greatly compress, the AUMF authorized the detention of enemy combatants, including US citizens. Therefore, wartime executive detention was legal. Since wartime detention was deemed as a fundamental and accepted incident of war, by extension, other fundamental incidents of war were also legal, and they enjoy the sanction of all three branches of government. Essentially, Hamdi rendered the Bush OLC's famous constitutional override argument unnecessary and folded an extraordinary wide range of commander-in-chief powers into the AUMF as long as they could be labeled as fundamental incidents of war. As the Bush OLC put it in the same legal opinion, the Constitution gives the president the full authority necessary to carry out the solemn duty to protect the American people, and he has made clear that he will use all authority available to him consistent with the law, the AUMF, to protect the nation. So why is it important for me to be doing this research? First of all, there appears to be a body of law that governs governmental action that we know very little about, and we've done very little analysis about. Secondly, we need to understand the impact of this law and evaluate the impact of OLC's opinions on the separation of powers, the power of the president, especially in the areas areas of unilateral action where the courts are unlikely to intervene. And that completes my presentation.
All right, thank you very much, Dorian. Amanda, welcome your comments.
Sure. Thank you, Shane, and thank you to all of our presenters. I'm going to say some general comments about all the papers and the connections I see between them. I have a few individual questions for each of the presenters, and I want to make sure I leave ample time for conversation and Q&A. First, I want to say a little bit about why I appreciate these projects. These projects are exemplars of grounded theory. We see theory being built from the bottom up based on rigorous qualitative data and empirical analysis. Each of these projects, in my opinion, illustrates the intersection between law and courts and law and society. These are two worlds that I exist in, and in many ways, my work also exists at the intersection. And so I appreciate the scholars who are bringing the insights from each to bear on the other. I think it's just making our scholarship smarter and better. Each of these projects decenters the courts in law and courts, right? Decenters judges. This is a drum I've been beating in this section for a long time, that judges matter, courts matter, but they are not the only sites, or sometimes even the most important sites of law, legal change, constitutional development. So each of these projects is shining a spotlight on lawyers as agents of legal change. So for example, Tom's project emphasizes that judges played a supporting role at best in the judicialization of European law, but that process was led by entrepreneurial Europe. David's project shows how the internal politics of public interest law firms can affect case selection, which in turn affects the kinds of cases that judges even get to hear, if they do get to hear them. So this reminds me of Charles Epps' observation when he wrote his classic work on legal mobilization support structures, right? Judges are a necessary but not sufficient condition for legal and constitutional change. They cannot wave a magic wand and make cases appear before them, in his words, as if by magic. So this is why cause lawyers are important. This is why legal organizations' case selection is important. So understanding the dynamics that drive that are important for understanding what kinds of cases ultimately make it all the way up to the courts. And finally, Dorian's project on OLC, the Office of Legal Counsel, emphasizes how a tiny office inside the Department of Justice acts as the final arbiter on more than 90% of the legal questions that affect separation of powers and executive branch politics. For a variety of reasons which he reviewed, many of those questions can never be adjudicated by courts. And for other reasons, courts choose not to adjudicate those questions. So understanding the Office of Legal Counsel as a site of law, legal development, and ultimately politics is really, really important and really vital. So now I have just a few questions that I'll address to each of the presenters. I'm going to go in order that in which I reviewed them. So David's work on cause lawyering is first. And David, I will say you anticipated almost every single question or critique that I'm about to give you in that first slide. So I've been doing a little bit more thinking about how I can kind of advise you along those lines as well as you were presenting. So first off, I think for a law and courts audience, you have to define cause lawyering. Right? That's a term that's so familiar. It's like a comfortable sweatshirt in law and society. No one needs to define it because we're all familiar with it. But in the world of law and courts, I think you have to define what cause lawyering is and what it's not, and why it's important. So also, what do cause lawyers have to do with politics? Or what is the theory of politics that you're advancing here? And I know that you were thinking that through in the context of this presentation. So I'll suggest a few. I already mentioned Charles Epps' work. That's something that's been deeply influential to my own work and how I understand my scholarship. But his idea of the support structure, right? This idea that what matters for long-term advances in law is not just what courts do, but the sustained judicial attention of a cause, right? Getting cases up to the court. You might lose some, you might win some, but the sort of radiating effects that can have for social movements, for politics, for other political actors, that matters. So I think Epps' work is a nice frame for you and this work. The second thing that came to mind as you were presenting, but it didn't come to mind when I was reading your paper, was about Vanessa Baird's work on judicial signaling and Supreme Court agenda setting. So when you're going through this interview data or the evidence that and the empirics that you've gathered around why these organizations are choosing the cases they're choosing, is there any evidence that they're paying attention to judicial signals? Right, Baird talks about how because courts can't wave a magic wand and make cases appear by them, sometimes what they do is send signals to lawyers who are attentive and attuned. And so that when they're ready to hear certain kinds of cases, there are different signals that they can send. And is that factoring into how these organizations that you study are thinking about what kinds of cases to bring and when? That might be another question to sort of think about. You mentioned, should you add other case studies? So I do think that comparing your case studies to other public interest law organizations, you don't need to do original research here. There's plenty of scholarship on other organizations that focus on different legal issues, right? Perhaps those on the right. That's the world that I'm familiar with, given my own work. How much of what you describe is peculiar or unique to LGBTQ issues and advocates? I think that's an interesting question for you to think through. This is an organization that seems to be, or this group of organizations seems to be very mission focused and mission driven. So you might compare that with organizations that also seem to be very mission focused and mission driven. I'm thinking here of Second Amendment groups, right? This is another single issue public interest legal organization that is going to be extraordinarily mission focused. Jim Bopp's group comes to mind. He's done work on campaign finance and abortion. And in fact, Ann Southworth and Mary Ziegler's books that they have out right now look at how those issues actually got linked. And so that might be an interesting kind of point of comparison for your work. Any anti-abortion groups or groups that are doing work on religious liberties would seem to me ripe for the kinds of comparisons you might want to draw, or even just to contrast with. So I think having that would make the case study more than just a descriptive bunch of empirics. There's so much rich interview data here. There's so much interview data here that sometimes when you're presenting it, the take-home points get lost. So my role, some of you know that I work at the Washington Post Monkey Cage blog. And so I kept saying, you're burying the lead because you'd sort of be very vague about, in the 90s, there were some changes that happened, but I didn't find out about them for another 25 pages, right? So don't bury the lead. If that change is what you're analyzing, foreground that change, and then think about what your data tells us about how to explain that change, right? It sort of gets buried in the middle of the paper. And then the causal question, you make and dismiss several causal claims in your paper. You say things to the effect of, something did not appear to have an observable effect on case selection. I want to know sort of how, you are determining that. And it doesn't seem like you're making strong causal claims, or that you have the ability to do so given the data you have. So I would soften those claims throughout so that you insulate yourself from the kinds of critiques that you get from a reviewer. Like, you're making causal claims, but you're not engaging in real sort of rigorous causal analysis. So those are just my general points. I think there's so much here that honing in on some kind of theory, what is this a case study of, right? It's not just a case study of cause lawyering, right? If it is, then I do think that that's a better fit for like the law and society literature, or maybe the law review literature. But I think there's more here, and you could get more purchase from your empirics if you connected them more clearly with some kind of theoretical framework. Okay, and then finally, Tom's paper. So Tom, I think this is a fascinating project. As I mentioned, I heard this first at an APSA panel. We were on a panel together in 2018. I can't wait to read this book. A few questions that came to mind as I was reading, and maybe you answer these in the book. How do you define judicial policymaking? Are you actually just talking about judicialization of policy, or is it something else? So I think here of like Malcolm Feely and Ed Rubin's book. They're talking about, when they identify judicial policymaking, that it's policymaking with socially desirable results in mind, right? Is that what's going on here, or is there something else? So I just wanted a little clarity on how you define that. And then the transition that you talk about, or you preview in the first chapter, from lawyers as ghostwriters to lawyers as advocates, that's fascinating to me. And I'm curious as to whether or not you think that transition was natural or necessary or contingent, right? What dynamics were at play that drove lawyers to become more sort of vocal advocates? Finally, not finally, you say that they're not, this is relatedly, they're not connected to social movements, or at least they weren't, you argue, in the beginning. But in their advocacy roles, are they partnering with social movements? I'd be curious to know how social movements view these lawyers. Do they view them with suspicion? Are they rowing in the same direction? Or are they working at cross purposes? I think there's probably an interesting story there I was curious about. And then this is finally, I'm really interested in their education. So in the context of particularly my second book, I'm looking a lot at how developments in legal education can shape lawyers who then go on to shape law, right? I know that you talk about the Euro lawyers sharing a background in terms of their corporate professional experience and that ecology of corporate law. Do they have any other shared sort of backgrounds in terms of, were they all trained similarly? Are there law programs that are training Euro lawyers to go into corporate law that then they sort of take that shared training? That was something I was interested in as well. And then Dorian, Dorian didn't send me an updated version of the paper, but this is a project that I've been familiar with since 2011. When I first started teaching, Dorian came out to Pomona College and talked to me about the work he was doing with OLC. So it's been really amazing to see this work develop over the course of 10 years. And I'm excited for the book, Dorian. I can't wait for it to come out. So as I mentioned, Dorian is doing work on executive branch legalism, which I also think is something that's vastly understudied in the world of law and courts. Probably because for the most part, courts are not involved in executive branch legalism for the reasons he describes. And the OLC, as he talks about, is effectively a mini Supreme Court. I have a new piece out with a former student of mine at Pomona College, who's now a Marshall Fellow at LSE, on why political science should pay more attention to OLC. And in part, we're drawing on Dorian's work here, but of course, we're sort of trying to understand the myriad ways that OLC shapes the separation of powers, bureaucracy, executive branch legalism. And that's out in Presidential Studies Quarterly now. Questions for Dorian. So these are questions I'm struggling with too. So maybe we can have a sidebar about this. How do you deal with the selection bias in analyzing only published memos, right? Because there's so many dynamics that go into what's published and what's not published. And when we know from interviews with folks who used to work at OLC that so much of the advice is informal and it's never written down at all, let alone published. So how should we understand that? How could that factor into your typology? Secondly, do you have a theory as to why some memos are published or not? That's something I've been curious about. What drives publication and what value does publication have? And a bigger question, I think this is a normative question that I'm interested in, is what are the checks, as you understand them, on the Office of Legal Counsel, on its power and on its influence, right? I ask because I do have a former student, David Janowski, who's working at the Project on Government Oversight right now. And they just released a report on the Office of Legal Counsel where they're very concerned about, the shadowy mini Supreme Court that's effectively making law without any kind of say from the people, right? These are lawyers who are appointed. They're not, democratically elected, and many of their decisions never see the light of day. I'm going to drop a link in the chat. This is one of David's reports on OLC, where he suggests a number of potential reforms, one of which would be to force OLC to publish all of its memos. But it's not the only one. There's a number of other reforms recommended: more congressional oversight, more control over who gets onto OLC, so more kind of visibility about that. So I'd be curious to know sort of how you understand potential checks and whether or not you think they're necessary on OLC. And I'll stop there.
All right, wonderful. At this point, if any of the panelists would like to respond, I see a couple hands up already, it looks like. Y'all would like to respond? I would ask, though, keep it brief so we can indeed open the floor up for folks to ask their questions as they might go. So any y'all question or feedback for responses to Amanda, I should say?
I just want to quickly say thank you. Those were, I've been wanting to just put this paper away for a while, just get it written and then just like put it away. And for the first time, I'm like excited to go back to it because of the comments, the feedback. And thank you. That was very thorough and very helpful feedback. So I'm very appreciative.
Yeah, you're welcome. And so shameless plug, my new book co-authored with Josh Wilson, Separate but Faithful. We have a whole chapter where we sort of refine EPS support structure theory and we develop a pyramid, and it might be helpful for you in kind of thinking through the empirics of your own work too.
Absolutely. Thank you.
Dorian, any responses or no?
I'd love to field questions and maybe comment at the end in case anyone has, because everyone's been very patient. But I definitely want to respond to Amanda's fantastic.
All right.
So I will. I would just say, Amanda, in chapter, I think 5 or 6 of my dissertation, I actually addressed the question of what are some potential checks on the power of the Office of Legal Counsel. I talk about their separation of powers jurisprudence and how the historical practice is really sort of the most significant check, if you will, on OLC legal interpretation. And then I also kind of talk about how the Bush administration kind of threw the baby out with the bathwater, and that kind of ended up leading to the torture memo and other aberrations. So that's the one thing that I wanted to say about selection bias. I think that there was a law, if I'm not mistaken, around 2008 or 2009, where OLC oversight, that law that would have actually required the executive branch to memorialize all legal opinions rendered by the OLC. But of course, that for a number of reasons, that's unlikely to happen. Very likely, even if it did make its way through Congress, it would be vetoed by any president. But I think those are interesting questions. And how opinions are chosen to be published. There's actually also a part of that in my dissertation. I talk a little bit about that, and usually it tends to be sort of for example, with the Carter memos, which I don't talk about in my dissertation. It was usually the Office of Legal Counsel says that a certain amount of time has to have passed for opinions to be published. And then how they are selected, which ones are published, which ones aren't. They say that those are national security considerations. So obviously, I think when it comes to the Office of Legal Counsel, I know that you've written about this topic too, and I really enjoyed reading your paper. It's something where we work with very limited information that we can get, and hopefully, the ACLU, other organizations that push the executive branch to publish some of these opinions, like the targeting memo, they can do their freedom of information requests, and then hopefully with that, we have more access to the data. But there's definitely that issue of selection bias, and also the limits of how much information we can get.
So I'll just point out that you're saying cause lawyers can serve as a check on OLC lawyers' connection between David's work and your work. Thanks.
I saw Christine's hand there.
Yeah, my question is for David. It's not really a question, it's more of a comment. But when you're talking about putting this in, what type of journal should you put this in, what type of format? I think if you place your work within the context of the broader American politics agenda setting literature and talk about political entrepreneurship and like have that broader frame, I think this will be really interesting to a broader audience. And I don't think you should restrict it to just law and courts people, but I think if you get the Baumgartner stuff out, I think that would be where I would go with this project if I were doing it. We can talk more about that. I do that in my dissertation. I'll shoot you an email, but I think that's probably the best way to go. I think a law review, like while cool, like might not be the best for you in the trajectory of your career. So I would stick with the broader American politics frame if I were in your position.
Thank you. One thing, I mean, it wasn't the garbage can, sort of old school garbage can theory of public policy, public agenda setting kind of occurred to me because it sort of like reminded me ways everything is kind of just like thrown together and shifted around. And so it occurred to me, but that's a really good point. Maybe like reframing it in terms of these canonical theories of agenda setting.
I think the 2004 Baumgartner and Jones, or maybe that one's the Jones and Baumgartner, I can never remember, where they talk about why do certain issues get attention and why do certain people within organizations pick issues over other issues. That's the thing I think makes the most sense for your research.
Okay, thank you.
All right, anybody else? I have one then. This one's also for David. David, you know, one thing that occurred to me is one thing that really surprised me that you presented was the that there's so much autonomy given to the staff attorneys. And, you know, one thing I started thinking about there is kind of organizational culture. You know, what is it? I have a feeling if we were like dealing with like, say, some like business group, there wouldn't be a lot of autonomy for that staff attorney. It's going to be, you know, you do what you're told on the higher ends. Here's your rubric, you apply it, and then some committee needs to approve. So I'm curious, what is it about the LGBTQIA plus organizations where you give this autonomy to the lower level groups? And perhaps most interestingly, over time, does that, sorry, that's the cat's tail right there. Over time, does it kind of quote unquote corporatize over time in the organization? We see differences in like, say, oh, I don't know, like Lambda Legal, which is big and established versus, I don't know how big GLAD is, but I'm assuming it's smaller than Lambda Legal.
That's a really good point. They say they follow certain typical bureaucratic models. I think they call it the Carver model of board relationships with staff. But there was definitely an element, I don't even know if this made it into the paper, where they would talk, I think it was Kate Kendall from NCLR, would talk about how they were, you know, radically feminist, and this sort of, they wanted to democratize their decision-making. And that meant like bringing in certain diversifying staff and giving them autonomy. So that's a good point. There's a certain element of decision-making that is actually influenced by their culture, which I didn't really put my finger on until you just said that.
And that's sort of just to piggyback on Shane's comment. I think that's where you could gain some purchase from comparing them to either another organization within the left that is sort of bigger and more well-established and bureaucratized, or an organization on the right that tends to be more hierarchical, right? Folks on the right tend to be less radically democratic and more hierarchical. So Alliance Defending Freedom came to mind. That's the big one that features in my current book, but then Josh Wilson and I also have a piece in on new Christian right public interest law firms, where we look at their kind of organizational cultures. So that might be a nice comparison case for you.
Thank you. By the way, me looking away from the screen is me typing. I'm not ignoring people. I'm typing away.
Totally good.
I don't think anyone can tell where anyone else is looking relative to the different boxes are different on everybody's screens.
Mm-hmm.
So if there's no other questions, I wanted to piggyback off of the feedback I got from Amanda, because those are really stimulating questions that that you gave. I guess Amanda, your first question for my book is how do I define judicial policy making, or how do I think about it? And I think this is actually a really important point, because what's happening in the European Union is two processes simultaneously. You have a more kind of traditional kind of understanding of judicial policy making, where you're mobilizing national courts in order to challenge state law and trying to cajole them to exercise judicial review powers that they historically have lacked. And you do that by appealing to this let's call it a kind of federal constitution, which is European law. But of course, national judges and policymakers don't see this as a kind of federal constitution. So what you also have to construct is a sort of federal structure. And one of the ways you do that is by creating a multi-level judiciary. And in order to create a multi-level judiciary, you need national judges to speak to supranational judges in Luxembourg. So what you're creating, you're doing two things at the same time. One, you're challenging national legislation, and you're doing it through this transmission belt, which is national courts, to try to get to the ECJ. But what you're also doing is you're creating a quasi-federal judicial order. And these lawyers had this strongly in mind, which is why I never refer to them really as cause lawyers in my book, because they're not driven by, say, these lawyers aren't appealing to the European Court of Justice because they have one particular issue area or agenda that they're trying to advance. Especially early on, they had this political project of forging a transnational polity and a transnational judicial order in mind. So any case could do, so long as it could be fodder for mobilizing national judiciaries to participate in this. One of the interesting things about why these aren't cause lawyers is I didn't find a lot of evidence that we have these transnational social movements that are akin to, say, the civil rights movement or the religious right movement in the US. And part of this is because you have these very distinct national legal cultures, very different forms of judicial training, different languages being spoken, different cultural reference as to where you're trying to reshape policy. And so with the exception of maybe environmental litigation, where we're starting to see one or two kind of transnational public interest law firms like Client Earth with some kind of social movement support, we don't really see this very much in Europe, which is why you have this transition from these individual mischievous entrepreneurial lawyers in the 60s and 70s to corporate law firms today, neither of which is really solidly anchored in a social movement. But that's, I think, part of what my book is trying to contribute, which is when we see lawyers doing things and engaging in politics, we shouldn't automatically presume, oh, they're agents or spokesmen for social movements or for interest groups. Sometimes they can be agents and spokespersons for themselves and for their own corporate interests as lawyers, as it were. And finally, the education of these lawyers, what's interesting is all the first Euro lawyers were self-taught because again, this is sort of different from, say, the American setting where one of the first courses you take in law school is constitutional law. No law school in Europe up until the 80s and 90s taught European law. So these lawyers, by and large, had to sort of teach themselves, and oftentimes they did it by working in these fledgling European institutions. So, they'd like work in the Office of Legal Counsel, as it were, the equivalent of that at the European Commission, and then come back home and open a law firm. So you have this really interesting kind of alchemy of knowledge that emerges, and only now, as Eurolawyering has corporatized, what you start to see is this pipeline of masters in economic law, especially like at Stanford Law School or Harvard Law School or the University of Michigan Law School, where they get to learn about American competition law, and then they translate that in the European setting and they practice European competition law. Or they go to the College of Europe in Bruges, which is another one of these elite kind of institutions to forge a kind of European corporate elite. So now we're starting to see it, but it's much more narrowly focused towards economic problems and serving the interests of corporations more than the public interest more generally.
That's fascinating. I feel like there's an article that could be co-authored about that sort of law school kind of training that's going overseas and serving corporate interests. And I guess the follow-up would be sort of what social movements are on the losing end of this move, if any, because they seems like a very kind of pro-corporate capacity building project. So yeah, do you have specific examples of social movements that are losing?
The interesting thing about it is scholars of American political development often sort of malign the weakness of the labor movement in the United States compared to Europe. So you'd think that labor unions in Europe would be at the avant-garde of this, and they would be able to counterbalance the corporatization of Euro lawyering, right? But the problem is that Europe doesn't have this culture of adversarial legalism. It has a much more corporatist culture whereby labor unions are incorporated into governance structure, and they engage in this kind of like behind the scenes lobbying with employers associations and mediated by the state, kind of the classic corporatist model. And so what this means is that labor unions by and large have not, and to this day are not at the sort of avant-garde of public interest lawyering. They're very reluctant to go to court. But corporations are not reluctant to go to court at all, especially due to the influence of Anglo-Saxon law firms that go to court very regularly. And then they bring that expertise when they open branch offices in European cities. So we have this kind of unbalanced form of litigation whereby Eurolawyering has become very much embedded in the structure of corporate law firms, but we don't have an equivalent of that, say in labor unions, which are still quite strong in Europe, but they don't tend to look very favorably to going to court, or it would be a very significant cultural shift.
One thing that kind of to piggyback on that, Tom, is fascinating to me, and I was even thinking throughout your presentation, is, you know, this whole idea of, you know, you look at like the US Supreme Court bar and you have like this small group of elite lawyers. I mean, if you got Ted Olson, if you've got, you know, Don Varelli, you're probably going to do pretty okay for yourself. If you're one of those, you know, like, you know, people who's like a one-timer or two-timer at the US Supreme Court, mileage may vary. And so I'm curious, you've got this like cadre of like super elite attorneys appearing at the European court. What percentage of them are like these elite attorneys, and perhaps even more importantly, who's hiring them? Because I mean, if like, I don't know, if like Microsoft is routinely hiring them, or Facebook with this like right to be forgotten thing, is that gonna give you better outcomes than say if you have like if you're just like, you know, the small little company that can't afford the fancy attorney?
Yeah, that's also really fascinating, because you do have this kind of elite group of repeat players that emerges really early on, where like in a country like Italy, my home country of Italy, where I can count the number of lawyers on my hand that were behind 85% of all the lawsuits that would get punted to the ECJ in the first 20 years of the Treaty of Rome's existence. So you have this cadre of repeat players. But in the early years, nobody knew what the European Court of Justice was. There was no sort of transnational European bar. So this was not a high prestige activity. These were seen as weirdos and curmudgeons, right? Which is super interesting. Later on, once European law became more entrenched, became more sort of revered as an important potential career track, as corporate law firms in particular endowed it with the kind of legitimacy and prestige that they tend to do when they sort of infiltrate a new legal field. Now you're starting to see specializing in European law as being kind of an elite activity, and in particular a passport to entering a multinational like law firm, like Cleary Gottlieb or Allen and Overy, or even national law firms that have tried to mirror the American structure of the corporate law firm, like Chiomenti in Italy or Gleislutz in Germany. So now you start to see more of this sort of elite group. And the reason why these are becoming the elite lawyers and they've supplanted the early kind of generalist political curmudgeon lawyers is because they can specialize into very niche areas of law. So as a legal field develops, it becomes more complex and you need to specialize, and corporate law firms provide the kind of infrastructure that allows lawyers to specialize. So could you be one of, if I wanted to go to law school in Europe to become like one of the early Euro lawyers who didn't really care about economic law, but was just trying to create a European Union through law and would just take any case possible to act as a vehicle for that, it's now impossible by and large, because you need to specialize because the legal field has developed. And that's why corporate law firms have a leg up.
Tom,
right.
I was just gonna, I'm sure you're familiar with this book. My colleague Heidi Haddad at Pomona, Hidden Hands of Justice, where she's looking at sort of supranational courts, but from a different perspective. Not Ghostwriters, Hidden Hands. So similar, but different. Shane has left us for a moment.
Can I ask one question really quick? I have it's kind of this autonomy question that we all have sort of like been talking about from different perspectives about the autonomy of lawyers and such. So like my question first for Dorian, and apologies because I didn't get a chance to read your paper, is like you clearly show that the Office of Legal Counsel has become this kind of like shadow internal Supreme Court. But I'm wondering, do you have evidence of situations where it's not just rationalizing political intent, in the sense of, are there clear cases where the Office of Legal Counsel constrains political power, or situations in the opposite view where political power doesn't particularly want to expand in a particular way, but the Office of Legal Counsel says, actually, if we do this, it would be really good. And so it sort of sets an agenda for political power. So do you have examples of that to sort of like show us the kind of autonomy or independent power of the Office of Legal Counsel? And then the second question for David is, it's really interesting how lawyers, mission-driven lawyers within public interest law firms like GLAD have a lot of autonomy in case selection and such. And my question is, beyond like the mission statement, do they think this autonomy works in the sense of, how does it help them? Are they trying, is the goal to win cases, or is the goal to sort of gain publicity for the cause, or what goal do they think is served by having this kind of autonomy where they're not just doing the bidding of donors, for instance? Like what end does this autonomy allow them to achieve beyond being true to themselves and their founding mission?
Dorian, you popped off for a second. You're back.
No, it was a perfectly timed power cut. To answer your question, the part that I heard, yes, Jack Goldsmith actually was head of the Office of Legal Counsel for about a year in the second half of the Bush administration. He wrote the book The Terror Presidency, and he actually talks about how certain members of the Bush administration were pushing him to interpret the Article 4 of the Third Geneva Convention to remove the protections of the Geneva Convention from POWs in Iraq, and he said no. I don't know if an opinion was memorialized. It's definitely not published. So we can't look at his argument, but he talks about what he says in that particular legal argument in his book. So there's definitely situations where the Office of Legal Counsel isn't just simply instrumentalizing the law for political purposes, but where the Office of Legal Counsel says no to particular forms of executive action. But what is very interesting is that I think that maybe the minority of cases, or the cases that I'm not that particularly interested in, because if you look at, for example, the drone memos that were produced by David Barron, and I forget the other gentleman who wrote that opinion. They kind of do the same. I'm actually writing an article about comparing the torture memo and comparing the drone memos, and I kind of make the argument that there's very little difference, except done by a different president and not as hasn't received perhaps that much public attention. But I think there's definitely those opinions that constrain presidential power. It's just that I'm more interested in the ones that don't.
Yeah, and just to piggyback on Dorian's comment, this gets at the problem of published versus unpublished, formal versus informal advice. So much of what we know is from these memoirs. And so we believe there are situations where they're on the phone with the president suggests something and they're like, oh, hell no. But here's an alternative path. I'll try to work with you to make that thing legal. So it looks like they're always saying yes, right? Because so much of what would arise to the point of no never gets that far formally. But yeah, I would recommend Terror Presidency. That's a great memoir.
And I think during the Bush administration, there was this former heads of the Office of Legal Counsel and former members of the Office of Legal Counsel put out this guideline for how to produce legal opinions, and they make this argument that there's different models of whether you work for the president sort of in a what's the word, in kind of a if whether your function is what Amanda just said, make it happen, find a legal avenue to make something happen, or whether your job is really to look at the laws and objectively decide whether there's a way to do it or there isn't, and that's actually a very interesting document that was put out. But I actually have read legal arguments by the same individuals who put out the document, and they appear to be very much in this advocacy mode when they are in that particular position. As we know, for example, Professor Coe, when he was not in government, he was very critical of the Office of Legal Counsel, and then when he was in when he was in the State Department and he did produce legal arguments, he was very permissive in terms of government action.
I would answer, but I know we're over time. Should I just quickly answer? And
we're totally okay. I mean, folks,
Yeah.
we can stay talking as long as we want. I'm gonna have to bounce out in a minute, but it's easy enough to just turn off my video and just leave y'all to it.
I don't have a life, so it's fine. The answer to your question, I think it's a good question. I think that gets back at an earlier question, and the question about culture. Because if you think about, especially organizations like NCLR that are inspired largely by feminist theories about that include sort of democratization, and that if you give more autonomy to greater people and a diverse group of people, that that's going to result in better attention to the needs of a greater swath of the target constituency you're trying to help, trying to aid. So I think that's part of the impetus behind enforcing and supporting greater lawyer autonomy, is that it'll help address more needs of the community. And it's also important to know, especially in the LGBTQ community, there is a lot of critique about the prioritization of issues. And there's beliefs that these organizations prioritize the needs of more privileged subgroups over more disadvantaged subgroups, and that funders, specifically major donors and foundations, tend to support those issues that are more favorable to those subgroups with a little bit more privilege than the other groups. And so there is a skepticism of the sort of model of funders influencing these organizations. And so I think that is also a part of why, and me saying that out loud and answering your question makes me realize that should be in the paper.
Because the reason I'm asking this is in my Law and Society course this semester, I taught Ellen Anderson's, Out of the Closets and Into the Courts.
My committee.
The thing is, what you're talking about now is not really present in that book, because there the focus is on legal opportunity structure. Sure. One big thing is how receptive are judges to particular legal claims. So the goal is, I'm going to select cases that fit the dominant legal frames that judges can understand so that I have a better chance of winning in court. But if you're talking about this more like serving the community, irrespective of whether it ends up actually being appealing to judges per se, I feel like that's an interesting move. Maybe it's the next stage of social movement and public interest law firm development, or maybe there's a stronger kind of potential tension with Anderson's book. But I think that's something to explore there.
And the other thing, another sort of contrast with Alliance Defending Freedom, because in my case study of the Christian right, I find that there are mission-driven folks who are very much about rebuilding the law from the bottom up. And that's how you best serve the community, by sort of reshaping the foundations of law, whether or not you win. And then Alliance Defending Freedom, who very clearly pivots away from that model to a more strategic model about reframing religious liberty as free speech. Why? Because they want to win. And so I think Tom's point is really interesting. And if you could kind of have your study at the intersection of
Yeah.
these questions, I think it'd be really cool.
That's very, I mean, so for Ellen Anderson was on my dissertation committee. So I cite her a lot, and it's interesting. I didn't like make that connection. And of course, Anderson it also relies heavily on Epp and sort of developing her theory of legal opportunity structures. It's the same as support structures that kind of Epp did. So it all kind of comes together. So this was super helpful, very helpful.
And Dorian, one last other thing that I thought about, like my PhD advisor was Kim Shepley, and she has all this super interesting comparative work on what she called autocratic legalists, which is about basically lawyers dismantling the constitutional systems they inherit through law, or undermining the spirit of the law through the weaponization of the law. And I heard a lot of parallels in what you were describing about the Office of Legal Counsel, obviously not necessarily with autocratic intent, although some of the things like, rationalizing torture or enabling torture certainly seems to fit that paradigm. But I'm wondering if that isn't a literature that you couldn't exploit, because it's about lawyers in the executive branch weaponizing law for illiberal ends. And it's sort of that classic retort to the sort of, Feely, Karpik, Halliday literature about lawyers always being agents of political liberalism and freedom. And this is instead the opposite, the dark side of the force, as it were. So that might be worth bringing in.
There's a quote from Tocqueville that I use in the context of my own work, which is, lawyers will always be the most serviceable instruments of a monarch's authority. So that's when I think about the OLC, that's how I think of it.
All right, great. Anything else, anybody? This has been a phenomenal discussion.
Thank you. I don't know whose idea this was, Shane, or if it was David's, but what a cool workshop and brown bag topic. And thank you for inviting us all.
Yeah, absolutely. For me, it's just sit back and enjoy. It's just getting to watch you all do the hard work of writing the papers, presenting the papers, discussing the papers. So I very much appreciate it. I will have this on YouTube and on the website, and share the recording on the listserv, hopefully within a day or two here. And if you have ideas for future brown bags, folks, that we should include, or topics we should cover, please do send them my way. So thank you all, and good luck grading. And if you finish grading, please enjoy staring at a wall or binging on something in order to kind of decompress at the end of the semester. And Amanda, I hope you get to do that this upcoming weekend when your grades are finally done.
Thank you. That's the goal, Shane. Thank you. And
All right.
thank you all for your great work.
Yes, thank you.
Thank
Take
you.
care, everyone.
Thank
Thank you
you.
guys. Thank you very much.
Bye-bye.
Bye-bye.